If something sounds too absurd to be true,
chances are it probably is.
Viva Frei, Montreal litigator turned YouTuber, and there has been a story that has been making its way around the mainstream media outlets. Sidney Powell, in her motion to dismiss the Dominion defamation lawsuit against her, says that no reasonable person would have taken her statements to be statements of fact. All right, let's back this up because I think I may be assuming that everybody out there knows the context. For those of you who have been living under a rock for the last 4 months, in the wake of the 2020 elections, an attorney named Sidney Powell had made some pretty outlandish claims as relates to the voting systems used in the election. Now, I am not saying this to pacify the YouTube gods. For anyone who's been around my channel for long enough, you'll know that from the very beginning, Robert Barnes and I were discussing with a certain degree of skepticism the claims that Sidney Powell was making. Not only were we skeptical about some of the stronger statements Sidney Powell was making in public, we were also noting that she was making some basic factual mistakes as relates to the corporate structure of Smartmatic versus Dominion, the corporate histories of the companies. She was making mistakes on facts. And Robert Barnes, who was more outspoken in his critique of Sidney Powell, said that if she doesn't watch it, she's going to end up with a defamation lawsuit. And whoa, she ended up with a defamation lawsuit against her in the order of
$1.3 billion.
Dominion Voting Systems in fact sued Sidney Powell and a bunch of other defendants for $1.3 billion on the basis that they were defamed by public statements Sidney Powell made. And the other day, Sidney Powell filed a 90-page motion to dismiss the Dominion defamation lawsuit against her, and according to the headlines, the grounds of defense she raised caused me to question the truthfulness of the headlines. From BuzzFeed News, Sidney Powell now argues, quote, no reasonable person, end quote, would believe her voter lies were, quote, fact, end quote. From CNBC, pro-Trump lawyer Sidney Powell says, quote, no reasonable person, end quote, believes election claims were, quote, statements of fact, end quote. From Bloomberg, Sidney Powell says her Dominion claims were opinion, not fact. As usual, when something seems too outrageous to be true, it typically is, and there is, in fact, a lot more to the story than what appears in the headline. Now, Sidney Powell has filed a 90-page motion to dismiss, and in it she raises a bunch of grounds. I am not going to go through all of them because they are irrelevant for the purposes of this vlog. She raises the issue that the court does not have standing to hear the dispute, and if I'm Sidney Powell, I am doing everything in my power to get this case out of the DC courts. But the arguments on jurisdiction are interesting from an academic point of view, not from a vlog point of view, so we are going to skip over them. Now, when it comes to defamation lawsuits, at the very least in the United States, truth is an absolute defense, but there are other grounds of defense. So if the statements are false, they can in fact be defamatory, but when it comes to public figures or matters of national importance, not only do these statements have to be false, they have to be made with actual malice in order for there to be defamation. So one would think that in her motion to dismiss, the grounds of dismissal would be that these statements are factually correct, and even if they are not going to be able to prove actual malice, hence they will not succeed on their claim. And Sidney Powell does in fact raise those grounds of defense in her motion to dismiss, which would make it somewhat mutually incompatible to simultaneously argue that no reasonable person would have taken her statements to be statements of fact. One cannot coherently simultaneously argue that the statements made were statements of fact if they were factually incorrect, they were not made with actual malice, and in any event, no reasonable person would have taken those statements to be statements of fact. So when I saw that headline, I said something here does not make sense, and I had to go read the actual pleading, and lo and behold, it makes a little more sense after reading the actual pleading. In the United States District Court for the District of Columbia, U.S. Dominion Inc. et al. Versus Sidney Powell et al. Memorandum of Law in support of defendant's motion to dismiss. In Kahane, the Colorado Supreme Court identified a two-step inquiry to determine whether a statement is protected. The first is whether the statement is, quote, sufficiently factual to be susceptible of being proved true or false, end quote. The second is whether, quote, reasonable people, end quote, would conclude that the assertion is one of fact. Quote, the factors relevant to the second inquiry are 1. How the assertion is phrased. 2. The context of the entire statement. And 3. The circumstances surrounding the assertion, including the medium through which the information is disseminated and the audience to whom the statement is directed, end quote. Okay, so now I can sort of understand the headline, but it gets a little more interesting as we read further. This makes sense because, quote, when a defendant provides the facts underlying the challenged statements, it is, quote, clear that the challenged statements represent his own interpretation of those facts, end quote, which, quote, leaves the reader free to draw his own conclusions, end quote. When, quote, the bases for the conclusion are fully disclosed closed, no reasonable reader would consider the term anything but the opinion of the author drawn from the circumstances related, end quote. Quote, because the reader understands that such supported opinions represent the writer's interpretation of the facts presented, and because the reader is free to draw his or her own conclusions based upon those facts, this type of statement is not actionable in defamation, end quote. So even on a minimal reading of Sidney Powell's motion to dismiss, you can already appreciate the idea that she is not saying that no reasonable person would have taken what I said to be a statement of fact. Rather, she is going to argue that everyone out there understood that I was stating an opinion at law that needed to be proven in court. She was publicly stating her legal position that would be presented in court even if it were to be ultimately dismissed, and lo and behold, that is exactly what she is arguing. Reasonable people understand that the, quote, language of the political arena, like the language used in labor disputes, is often vituperative, abusive, and inexact, end quote. Hey Siri, what does vituperative mean?
Vituperative means bitter and abusive.
Okay, good to know. Moving on. It is likewise a, quote, well-recognized principle that political statements are inherently prone to exaggeration and hyperbole, end quote. Given the highly charged and political context of the statements, it is clear that Powell was describing the facts on which she based the lawsuits she filed in support of President Trump. Indeed, plaintiffs themselves characterized the statements at issue as, quote, wild accusations, end quote, and, quote, outlandish claims, end quote. They are repeatedly labeled, quote, inherently improbable, end quote, and even, quote, impossible, end quote. Such characterizations of the allegedly defamatory statements further support defendants' position that reasonable people would not accept such statements as fact, but view them only as claims that await testing by the courts through the adversary process. So the mainstream media headlines are mostly true, which necessarily means that they are partly false. So although it makes for a catchy headline and certainly makes Sidney Powell look like a stupid hypocrite, it's not the case that what she was saying was that no reasonable person would have taken my statements as statements of fact. She is saying that reasonable people would have known that I was making those statements as an advocate in the context of pending litigation. Additionally, in light of all the circumstances surrounding the statements, their context, and the availability of the facts on which the statements were based, it was clear to reasonable persons that Powell's claims were her opinions and legal theories on a matter of utmost public concern. Those members of the public who were interested in the controversy were free to and did review that evidence and reach their own conclusions, or awaited resolution of the matter by the courts before making up their minds. Under these circumstances, the statements are not actionable. Kahane. Finally, the statements in question are not actionable because they were made in the context of pending and impending litigation. The Supreme Court long ago recognized that, quote, the right to petition extends to all departments of the government. The right of access to the courts is indeed but one aspect of the right of petition, end quote. And First Amendment protections are not limited to filing lawsuits. They extend to activities that precede or are concomitant with the litigation, such as soliciting clients, publicizing the possibility of legal redress, and gaining public support. So it is true that Sidney Powell was saying no reasonable person would have taken my statements to be statements of fact, but the inverse is not necessarily true in that she's not saying that everyone would have known the statements were false. Her argument is that in the context, everyone would have known that she was presenting a position that she intended to present to court, even if it would ultimately be laughed out of court. And in law, there is a concept known as litigation privilege, and that is the idea that lawyers typically cannot get sued for defamation for presenting the position of their clients. It would have one heck of a chilling effect on the practice of law if every time a party lost a lawsuit, the lawyer would get sued for defamation because the facts they presented were in fact factually incorrect. That being said, there are in fact limitations to the notion of litigation privilege, and if an attorney goes out there and makes outlandish claims that he or she should know to be false, or he or she knows are in fact false, he or she can in fact be sued for defamation. That lawyer can nonetheless be sued for defamation even if the statements they made were only the position of their clients, if that lawyer knew those statements were false or, might have falsified evidence in order to present that position. And there are other circumstances in which an attorney can nonetheless get sued for defamation even if all they were doing was representing their client, if they made public statements that had absolutely no relation to the litigation itself. And just think of the case of the Osundaro brothers suing Justice Smollett's attorneys, Garagos, for statements he made out of court. So while I predict that Sidney Powell is in fact nonetheless going to lose, and lose hard, on her motion to dismiss, there's a little more nuance to the headline, and mainstream media is not exactly giving the full thrust of the argument that Sidney Powell is making. And why would they? Because typically people only read the headline. It is easy to mock Sidney Powell with that headline, and she is right now a very easy political target. All that to say, although I think she is going to fail on her attempt, there is a little bit of merit to what she is arguing. Alright, my prediction is out there. We will see where this goes. If you like my videos, you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below because it feeds the algorithm. If you want to support the channel, all of the support links are in the pinned comment, and if you support the channel, Barney will be very happy with you. Robert Barnes and I do weekly live streams every Sunday. We do the sidebar with Viva and Barnes with a guest every Wednesday. Robert Barnes and I also have a page on Locals. It is called vivabarneslaw.locals.com. All of my content is also on Rumble, but more important than that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and Now you know your vlog. Peace out. Booyah.